Town Session, the Honorable Judge George C. Ferris presiding.
You may be seated. All right. Okay. We have a problem.
Your Honor, initially Mr. Plank was subpoenaed to testify live today. We were under the impression that there would be reading a portion of his deposition and then he would be testifying live. Now I'm of the understanding that we're just reading in his deposition. He's not coming live at all, so we have canceled him. The issue that Mr. Woodward and I have now is that in reading the highlights that he plans to present for Mr. Plank's deposition, I have highlighted additional portions which I believe give context and which are permitted pursuant to Trial Rule 32 to be introduced at the same time he's reading Mr. Plank's deposition. He disagrees with me as to the portions that I've highlighted in almost every highlight that I've made. So I'm not quite sure how to resolve this if we need to go through them one by one.
So what you want to do is he's reading the deposition, you want to interject your...
I want the deposition read in order with the sections that I've highlighted that provide context to the sections that he has highlighted. I think that he wants me to read the sections I've highlighted later, which will make little to no sense to the jury and quite frankly confuse the heck out of them. So I think for continuity, for efficiency, for this to make any sense to them at all, and because I believe I am entitled to do so pursuant to Rule 32 to have the portions interjected in correspondence, I'm asking that the segments that I've highlighted be read in consequence. In sequence, I'm sorry.
Counsel's argument rests on a faulty premise. That is, everything they've designated is for contextual purposes. Now, the rule provides that, but I think it's 32.8.3 or 4, 32.8.3, provides that an additional question or answer or series may be read in to provide context. However, they've designated entire pages, in some instances, 2 and 3 pages of additional material. That doesn't provide context. That's straight out testimony. That I can't be obligated. They can't tell me what to put in my case in chief, number 1. Number 2 is the rule clearly provides that any other party can put in other portions if they so desire. So, if they're unhappy with the portions that I've designated, they can come back on cross-examination and read in the portions that they want in front of the jury. The other problem I have is several, if not almost all of the portions that they want to put in contain inadmissible evidence. I intend to object when they want to read that in front of the jury. So there are a number of problems with what they've designated.
I could go through example by example. The vast majority of these are literally highlights right in the middle of the segment where he's highlighted, he stops, and then he highlights again. They provide the additional portion of the testimony. I haven't been provided any examples of objectionable material, so I don't quite know how to respond to that. But I think that if we're going to be reading these little snippets in the middle here and there, for instance, 86 to 87 of Mr. Plank's deposition, and I can give example after example. He's reading, he's asking him to look at the page that pertains to the equity requirement in the loan agreement. Did you have the 210 in account? No. Did you have the 210 account with Fifth Third? No. It's going through his testimony through page 86 into page 87. Then I've highlighted lines 3 through 16 on page 87. His highlight picks up again on line 16. This is just providing Plank's understanding of what's going on. And that's the portion he doesn't want read in. My next
he's presenting his.
I'm sorry, what was that?
He's not objecting to you reading it in. He's just objecting to reading it in at the same time.
Right, which of course, if I don't read it in at the same time, the jury won't have any understanding of what it means. Your Honor, do you have a copy of the deposition?
Yes, I do. Where are you at, page 86?
I'm at page 86 to 87. highlighted up through page 87, line 2. My highlight starts at line 3 and ends at line 15. And then he starts at line 16 again. He picks up there. Then he continues on through page 87, page 88, 89. He stops at page 89 on line 8. He's been talking about
How much of this deposition are we reading in?
almost all of them.
That's not true.
Almost every
Roughly
page.
half of it. And I have intentionally deleted substantial portions because I don't want to be reading a deposition in front of the jury for the next hour and a half or 2 hours. They're going to fall asleep.
It's going to be at least 45 minutes, though, wouldn't you say? At least 45 to an hour.
Not only that, but there are substantial portions that we've agreed to read in, even though I don't even think we're obligated to. We've agreed to do it anyhow. So if they want to come back and read that portion, they're certainly entitled to under the trial rules. But they can't force me.
Why are you reading the dep instead of having him testify? I thought he was
Because
going
he's
to...
in a wheelchair. I don't even know
He
how
was planning to
well.
come today.
Just because he's planning to come.
When did we agree to do this? When did we decide to do this with the depositions? Just
We
this
didn't agree
morning?
to do this. He was subpoenaed for 9 a.m. He was coming. I just called and told him not to come because they're going to read the deposition instead.
They don't have to agree. It's my right under the
Well, I
trial rules to read
understand.
one portion
I understand.
Or all of the deposition. If I
I'm just
subscribe.
trying to figure out how this all happened or why it happened, why we're doing it this way.
I provided them the portions that we were going to read in before today. Provided them yesterday so that they could have ample opportunity.
All right.
Which I'm not even obligated.
I mean,
to do.
I've had this before with, they've taken snippets from video deps and then the other party goes back and plays their snippet, so we'll let Mr. Woodward proceed, then you can read in what you want to read in to try to rehabilitate it. I mean, it comes from the same pages, same testimony.
I think we'll have to
I found that the jury was able to understand it, you know.
Your Honor, I think we'll have to reread in significant portions that he's already read in order for the jury to understand it, because it's literally in almost every instance right in the middle of the testimony he's highlighted. So,
I disagree with that. That's not true. They are distinct and separate areas of concentration for the deposition.
and Your Honor, pursuant to Rule 32, if only a part of the deposition is offered in evidence by a party, an adverse party may require him to introduce any other part which ought in context to be considered with the part introduced. So,
And so what they want me to do is introduce every part that they designated, and they don't unilaterally get the choice to say, these make it into context. I disagree. It doesn't make it into context. If they want to reread portions of the deposition, they're certainly entitled to do that, Your Honor.
I think that's what you need to do. You need to just reread it.
okay, I'll have to reread it then.
I mean, I don't know who the jury's going to blame for all this, but probably
We'd
someone.
rather have Mr. Flake testify like we were planning to, but I don't know what else to do.
I guess you could call them.
Well, it's not our case in chief. I don't think
Okay.
Your Honor, so you know what we've done, because the deposition exhibits are
Now, how's the jury going to follow this? I mean, do you have it set out so what are you going to tell, refer here, refer there?
what we're going to do, well, a few things. That's what I was going to take care of, housekeeping right now. We prepared a sheet that references the deposition exhibit and now the trial exhibit. So when we read the deposition, we'll be referring to the trial exhibit number. So what we're going to do, we have jury books of the exhibits. There are 3 books. 1, the joint exhibits, you each agreed to. 2, our exhibits. And 3, Plank exhibits. So they're going to have 3 books.
And these are all exhibits, there's no objection to any of these exhibits that are here?
I just got some more pages, this morning I'm going through it as you speak.
I mean, we don't even know what exhibits are going in?
Well, we do as to the joint exhibits for sure.
Okay.
And if they have an objection to our exhibits that are referred to in the deposition, they can certainly raise that while I'm reading. Substantive objections, as Your Honor knows, are reserved for trial.
Right.
But I don't think there's anything in there that's objectionable
Okay.
from our standpoint.
All right, well,
The
let's...
only caveat that I have is there is one exhibit, the credit memo, which is exhibit, or joint exhibit 2, there's a portion of that credit memo that references an appraisal that was done in order for the bank to approve the loan. That's clearly admissible, but it's only admissible for a limited purpose. That is, because this was all speculative, there were no leases in place, there were no buildings in place, it was the bank's attempt to justify how much can we loan on this particular job. Now, what I don't want to happen is city center to get up at the close of the evidence and say, see, this is what the value was, because that valuation would fail from a proof standpoint for the same reason that Dennis Larson's evidence fails and his testimony fails, because it doesn't comply with the law as it pertains to the computation of damages and a breach of contract or failure to loan money. So, we have no objection to the introduction of that exhibit. We just want it limited to that use.
You know, I don't think that's it. I thought we were trying to figure out what the stipulated exhibits are. Obviously, we're going to use their documents to cross-examine their witnesses, and they've made statements and admissions in those documents, and we'll use them.
Well, an appraisal by a third party isn't an admission of anything. It's your state case.
I'm not sure why this is done before the...
I'm not sure either.
I'm not sure there's an objection.
I'm not sure I understand. You're saying it's going in, but you want it to go in for a limited purpose?
Sure. That happens all the time.
When are we going to get to that limited purpose? I mean...
Probably during the, well, I imagine we wouldn't even get to it until maybe from Brian Speck, probably through Brian Speck.
Well, why don't we see when we get to it in what context
So the record's clear by agreeing to his admission now. I'm not agreeing that it's admitted for all purposes.
Okay. That's fine.
With that being said, Your Honor, I think we're ready to go.
All right, we ready to go?
I'm going to lower the screen if that's okay.
Yeah, if you would. You don't have a video dub of him, do you? Wasn't a video dub of it.
It was before he had his health problems, so
Okay.
we didn't know.